When granting an option, you have to be very careful to lock in the voting rights and the power over those shares. So yes, you want your employees or your consultants, advisors, or board members to have the equity, to have the value added that's going to come from the sale of that stock eventually. But as you build your company, it becomes very awkward and inconvenient if you have 10, 20, 50, 60 employees who are all holding a few shares and have rights to those shares as a shareholder in votes and needing signatures. So we strongly recommend that every option plan have in it an obligation when an employee exercises even 100 options to not only sign the shareholders agreement, which is imperative, but also sign to a voting power of attorney. Typically, that power of attorney is given to the CEO or to the board of directors and ensures that their shares will be voted the same way as the board or the CEO votes his shares, or the board recommends how shareholders vote their shares. This way, on a transaction like a merger and acquisition, we just need the CEO to sign on behalf of all of those employees who've exercised their options. It makes it convenient. The employee as a shareholder still is entitled to the rights as a shareholder, which includes getting the financial statements and electing the board, but the election of the board is done through the recommendation of the board or the CEO. I know that sounds a bit complicated, but it is a method to streamline the workings of the company in an efficient manner, especially when there are transactions or financings or other situations where shareholders' approval is needed or where the board needs to act quickly.